Hello, y'all. Everybody doing good today? Looking good anyway. Hi, LaShonda.
Hi, how are you? I couldn't get
Yeah.
myself off mute in time enough. How are
Yeah,
you
sometimes
doing?
I wish I could put myself on mute. Don't you?
Yes.
Oh, lousy. I just got off the phone with an investigator from the real estate commission, so I'm sorry I'm a couple of minutes late. I didn't realize what time it was, but every now and then they like to call and check up on y'all and make sure you're behaving. So, hey, Brian, I thought I'd let you know I did talk with the attorney yesterday, so I'll talk to you afterwards, okay? On
Oh, well,
that matter
good,
that
good.
we
I hope
were
that's a good
talking
conversation we're
about.
gonna have.
Okay, okay.
Let me
Yeah,
let me
yeah,
find
it's a good,
Brandon
good,
here
good
too.
conversation.
There he is.
Oh, there he is. Okay, your your guy in partner in crime, right?
Yes, ma'am.
No, you aren't in crime. But anyway, well, we're going to be talking about listings today. Boy, I'm beginning to see you all get some listings that our sellers deciding to sell after all.
Home sell during the holiday, Saber. You know that.
Well, I know. I mean, but y'all are doing a go, Brandon. Y'all are doing a good job of convincing them that houses do sell during the holidays. They might not want the traffic, but houses do sell.
That's okay. We can restrict showings around those days that you don't want to show, Saber. It's okay.
Oh, oh, look
People
at
are
you
more
giving us
emotional during the
look at you
holidays.
giving us a script. Way to go, Brandon. Way to go. Oh my goodness, my goodness. It's always so good to see all of y'all. Hey Chad, hey Tyler, good to see y'all.
Hi.
Let me see if I can
Hello.
get us some forms. Are y'all doing good?
Yep, doing good.
Good, good, good. All righty, let's see what we can get into today. We're going to basically go through the basic forms. As some of you have gone before, but I hope that repetition will give you some additional insights into the forms. And I just spoke with one of the ladies, one of our agents just a while ago, and she was saying, I think I need to come back to the forms class. So I think she's on there on here too. But you know, it's amazing when you don't use those forms every day, how easy it is to lose some provisions. And but you all keep me on all those forms all the time, so I appreciate that because that doesn't let my mind slip too much on it. All right, let me pull some forms up here and let's see what we can get into. Oh, my stars, looky here. I've got my forms and I'm going to see you all in a minute. Looky there, it worked. Oh, I'm so thankful. I spent 2 weeks trying to figure out what was going wrong with my PDFs. And so today's a good day. Even if I did have to talk to the investigator, it's a good day. All right. Let's take a look at the first form that I wanted to make sure that you all had. I'm not going to spend a lot of time on it. I think just having an overview, this is just like the map. This is your Google map of a transaction. So one of the agents was saying yesterday, he said, I just don't have an understanding of all the pieces in the transaction, and because he hadn't gone through one yet. And so I was thinking about this form again because it kind of gives you that bird's eye view. If you will concentrate on the flow chart here and using the home selling process, because see, you as a listing agent, you actually have two two categories to work in. You work as the listing agent, but then you work as the listing sale agent because you need to know how to handle the transaction, the sales transaction as the listing agent. So you have to function in two mindsets basically. And if you'll just kind of get this overview of the process, maybe that will, assist in your understanding of what we're doing here. I'm not going to spend much time because I want you to spend some time processing it and following the flow chart and seeing what aspects of it fits you and what aspect might not fit the way you're going to be doing business. Some of you, those of you who are on teams, you're going to have a flow chart that's going to look a little different. Whereas this primarily would be a general oversight. If you're on a team, the team is going to have some boxes in that flow chart that's going to look a little different. And so you might want to fit those in. Okay. Now let's go on down here to, oh, I want to show you this too. There are exemptions to the residential property disclosure, and this would be the legal explanation of those things, those categories of exemption. So I just wanted you to have that. You know, sometimes you kind of like to have the legal entity as it revealed to you. Okay. Now, this little page here basically is again, just it's more of an understanding of the steps that are involved. I showed you the drawing of the flow chart. Now I'm going to give you the words. We're going to kind of have some lists of what you're going to do in the listing. I prefer to use what's called a pre-meeting, a pre-licensing or pre-listing meeting. And I think if you will find a way to develop a system where you can get some papers in the seller's hands before you actually sit down and meet with them. When you go to do a listing presentation, you're going to be presenting from the marketing standpoint. You're going to be sharing your value as to why they should choose you and or your team on Keller Williams. You have the marketing aspect, but then you've got all these forms that need to be filled out too. So get yourself into a routine or what we would call a system as to how you want to do this. Some agents prefer to mail, 2-day mail, which that's an oxymoron these days. You say two-day mail, it may be 12. They forgot the other 10. But we used to mail them a lot. But you know what? We have these wonderful e-signature programs that you can just send them over digitally. But you would want to get some of these forms in the seller's hands early on because they're going to have to fill out a lot of forms. And the earlier you can get them, the better it is as you're trying to put together your listing and put it in MLS. But as you are getting yourself ready, you're going to prepare the listing contract. That's going to be your NCAR 101, unless it's land. If it's land, it's going to be the NCAR 103. You want to make sure that you have that work with real estate agent's disclosure. And the disclosure is the 2-page document, right? One page is for sellers and 1 page is buyers. That's the disclosure form that you must use now as of July 1 this past year. No grace period. All right. Then you also want to have a copy of the residential property disclosure. It's called residential property and owners association disclosure. Those 2 categories are in that one form. In North Carolina, you are required to have a mineral and oil and gas rights mandatory disclosure. That is, I guess the legislators meant for us to use it. Reckon that's why they put that word mandatory in there. But let me tell you what you don't have to use that for. Land. Isn't that strange? You don't use the MOG, as we affectionately call it, for land. Nor do you use it in a foreclosure, nor would you use it in an estate. All right. Gotta tell you, last night, one of my agents was having an issue with a cross-sell agent and found out after they went under contract that it was an estate. They didn't put it as an estate in MLS. And guess what they put on as attachment? Residential property disclosure and a MOG signed by the executor. It's like, what? So now why they're exempt, first of all, if it's an estate. Then you get the executor to sign it. And I said, now they've got a contract, it's probably not even valid because they wrote it in the name of the executor. And so we had a mess to clear up last night. So all that to say to you, If it is an estate, you don't use a residential property disclosure nor the MOG. No, same thing for foreclosure. Okay. Now, again, I don't know if you all saw last week. Did you see the bulletin that came out from the legal hotline about lead-based paint disclosures? I don't know if you saw it or not, but I did. And I read those things religiously. As I read that, I did not know. Did you know you could get fined up to $16,000 for not having a lead-based paint disclosure? Whoa. Now, I think you all do a really good job. I don't have too many worries about you, but it really set me back when I saw how much the fine would be if they could prove that we didn't. And listen, it's for sales and for rentals. I know we don't handle property management. We don't have a lot of rental business, but if you have a personal rental, that you're handling, make sure that you get the lead-based paint disclosure that is in our library forms for as a tenant. Okay, so that was kind of an eye-opening thing. I thought I might better remind you all who have your own investments to make sure that you use that as well. And then, of course, you are going to want to look at your MLS data input sheet. After we've done a few listings and put a few listings in, that data input sheet is useless to us. But when you're first learning to do your input on your MLS listings, that input sheet is valuable because you can make notes on it. It's a worksheet. And then you're going to take that worksheet and do the data entry. Those of you who might have an assistant or be on a team that has assistants, then having that input sheet is very valuable because then you can pass that on to the person who's actually going to do the data entry on the MLS. Those of us who do our own data entry, sometimes we don't actually fill out that input sheet. Now, these things in this list are the things that you would want to gather from the seller. The tax bill to verify what city or township to collect taxes, in addition to the county the property is located in. Just yesterday, things have always happened in the last 48 hours for me. One of my big teams had gotten a ding, a notice of a fine from MLS because one of their admin had entered Mecklenburg County as the tax location. When you're doing your input for the listing, you must determine if there is a tax assessed over and above the county. If there is a township or a town, city, whatever it would be called, that's in addition to the county, the tax location becomes that township. In this particular situation, it was actually a Charlotte tax, the city tax that was on the bill. So the tax record might just show the county as the tax records, but you need to do some research and make sure that there's not a county that is in addition, or they have the additional taxes, because obviously the taxes are going to be higher than what would be anticipated. There's a little, I don't know what you would call it, a corner up in Huntersville and that area that actually it's Mecklenburg County, but they pay Concord city taxes. And I'm not really sure how that works out, but there's an area up there that one of our agents got a real serious eye-opening experience at closing when the buyer had to pay an extra $100 a month because of taxes that were paid to Concord. So all that to say is if you can collect a tax bill from the seller, the owner, you can look on that tax bill and determine if there are taxes other than the county. And that's why MLS is going to want you to put that as the tax location. Copies of utility bills. You know where I'm going with this, don't you? That's to find out if they have a septic or sewer service and what the water service is to this particular listing. So if you can get a utility bill You don't have to make any telephone calls. You just put the information on your sewer and septic and water agent discovery form, and you're there. If you can't get a utility bill, then you got to make some telephone calls to verify whether or not it is on city county water. Also, you would like to get a copy of the seller's deed. Most of the time, I know in Mecklenburg County and in Union, I'm not sure about all the other counties, you can actually pull a copy of the deed. There is some discussion as to whether or not we should be pulling deeds. I've heard both sides, and we're told that we need to find out who actually owns the property by looking at the deed. But we've also been told by attorneys that that's the attorney's job. The attorney is the one who pulls title. They are the ones who do the looking up at the deeds to interpret the deed. All I would want you to look on there is to see if the name of the person on the tax record matches the name of the person on the deed. Don't want you to go any further than that. But particularly, let's say like maybe it's an estate. This morning I talked to a lady whose mother died in 1991, and she's now selling some property. That's 30 years ago. She's now selling some property, and they've never settled the estate. So I was asking her, I said, whose name's on the deed? Do you have the right to even sell it? So she confessed at that point. She said, well, no, I've been paying the taxes. And I said, well, you may pay the taxes, but you don't have the right to sell that property if the property is still owned by your mother, even though your mother's deceased. So we had a long discussion on that. So all that to say, you need to find out whose name is on the deed, okay? You want to get a copy of a survey, if possible. A survey is a copyrighted document, all right? It's only as good as the date that it's done. So you want to make sure that you don't pass the survey on to another party. So if you put a survey on MLS, which you can do, make sure that that next buyer does not rely on it as the current survey, because it won't stand up. All right, so you want to make sure that they know that the survey is available and you're providing it, but they cannot rely on that. They would need to have their own survey. They need to talk to their closing attorney about that survey if they need to, and preferably that they would get that one updated by the surveyor who did it, or get a new survey, okay? The deed restrictions and covenants. I can't tell you how valuable they are. You really need to have those copies as soon as you can get them. And remember, a seller can get them from the homeowners association because they make their monthly payments or their annual payments, whatever the time frame is they pay their dues. They can get them free. But if you as an agent call to try to get them from the HOA or the property manager, they're going to charge you. Okay, so get the seller to contact, if it is a property manager involved, to get them. Now, sometimes there are deed restrictions that only a title search is going to reveal. The seller may not have ever seen them, but some things might pop up on a title search. But again, the closing attorney is going to work with you on that. But if you can find your CCRs, make sure that you're going to make them available. And our forms really require that they be made available prior to the buyer writing an offer. So I would make them available if they can get your hands on them, okay? The HOA association bylaws, rules and regulations, dues and assessments, that which you know, or which the seller knows, has got to be disclosed on that residential property and owners association disclosure, okay? And they also need to be made of there's aspects of it in the fields of MLS. When you when you enter the listing in MLS, there's some fields to be filled out with that. So make sure you find out as much about that on the dues and the assessments as possible. And you want to find out the balance due on the seller's existing mortgage. Sometimes sellers don't want to tell you, and sometimes they just feel that's their private business. It's not something that is required on the listing agreement, but I would say to them, basically, you're going to do a seller's net sheet. And if you know what their payoff or their balance is, you can more accurately do your estimate. And also you can give the information to the attorney, to the closing attorney, when you do get a sale on the property. But again, it's not required to list the property. Now, when you meet with the client, then here are some of the steps that you're going to be going over with. Whoops, somewhat too far. I don't know why it's skipping the page too badly. So one of the primary things you need to talk to that seller once you've sold yourself and your company, you want to make sure that you explain agency. Agency is the way we do business in North Carolina. Until you have a listing agreement signed and or a buyer's agency agreement signed, you can't do business with them. All right. You can't present offers and accept offers and counsel and do the things a realtor does. So they need to know as much about agency as you can explain or as they can accept. So make sure that you start with the real estate, working with real estate agents disclosure. You start with that, and it's a very simple explanation. And again, we're going to go through that in a few minutes, but I just wanted to point out that one of the primary things you're there for is to explain and to start establishing an agency relationship, okay? And you are required to caution them not to tell you motivation or any confidential information until you do actually have your listing agreement. You want to discuss the advantages of using a national firm, which is the branding. When I first started with Keller Williams many years ago, there were very few red signs around town. I got to tell you, because it was so new, and you just didn't see very many red signs. And now I'm happy to say there's a lot of red signs out there, and having that KW national branding is very helpful to you. People know KW now, and as a result, they have a trust factor. And thanks to those of you who are doing a really good job out there. You want to discuss with them how you're going to market the property. Don't spend a lot of time on it, but how you're going to market, because they want to know how you're going to get that buyer. Right now, it's just put a sign in the yard, right? But that's not always the case. And you're going to discuss brokerage fees with them. Again, we will get into that as we go through the listing agreement. As you're collecting the documents that you need or to put into MLS, or as you want to make sure that you identify personal property, that is so important. So now let's go on down to page 2. And I don't think there's too much more that I want to list of the things that you want to do, other than that all these things that are listed here, these are the things that are on that data input sheet. So that's going to help you. One of the things that my eye just picked up on this one right here, when you look at an MLS sheet, and obviously you're going to be putting yours in, but know what an SA is and what a BA, when they put the capital letters S, the capital letter A, or BA, that is the buyer's agent is obviously your BA. The SA is the selling agent. It is not sub-agency. And a lot of times people think that it's a sub-agency, but you want to make sure, excuse me, I said that backwards. See, that's exactly what I didn't want you to know. The SA is a sub-agency. It is not selling agent. The selling agent would most likely be your buyer's agent. We do get confused on that sometimes. In our market center, we do not cooperate with sub-agents from other firms, okay? So our SA is always going to be 0. We do not cooperate with a sub-agent from another firm. We are the sub-agent for this listing for the seller. So we are going to get paid the listing fee. We're not offering an SA for someone else to come in and do our job, all right? We're going to cooperate with buyer's agents only, actually. Typically, you do not list the seller's name or phone number in the MLS. And primarily that's because you don't want to have it make it too easy for a buyer or a buyer's agent to cross agency lines, which sometimes people do, and reach out to your seller. So typically we're going to put withheld. Sellers don't necessarily want their name and their phone number broadcast anyway. So you're typically going to put W/H or write the word out withheld. So you rarely are you going to see the seller's name or phone number. Again, I talked about the tax location up here. This is just a reminder of that. And you want to add your disclosures to the listing agreement, the listing in MLS. Now, one of the things I want to point out to here, never enter into the MLS remarks numbers, whether it's a combo lock number or it's a phone number. They don't want numbers in there, all right? You'll get dinged by the CMLS checker if you do. A combo lock, and you've heard me expound on this before, I do not like combination locks. You really need to use the Supra iBoxes. Those, because of the safety, actually when you put your Supra key in that iBox, it records whose key was used to open that door, and that's a real good safety feature. If you use a combo lock, there's absolutely no way of knowing who has accessed that house. And furthermore, it's too easy for people to look over your shoulder or to watch you open a combo lock and use it themselves. We have had 2 instances in the years that I've been a broker of buyers actually getting the code and moving in the house before they closed on it. One had just moved his clothes in, and the other was actually he'd been in there and had a shower. And it's like, what part of this part is you don't understand that you don't own this house? Well, I've got done a contract and I'm closed in X number of days. They still don't have a right to use that combo code and get in that house. So just be cautious if you choose to use a combo lock. Every now and then, you might have taken the Supra box off and only have a combo lock for, say, a workman, the contractor who might be doing some repairs in there, because obviously they can't go in on your Supra key. I have seen that, and that often works okay. But just be cautious not to don't put gate, like the gate coming into the neighborhood. Sometimes put those in there. Don't do that. Don't put numbers in the remarks, whether the public or agent. Don't put numbers in there. You want to obviously complete your septic or sewer agent discovery. Continues to be an issue. You all are doing so well, and I know you've grumbled some, but most of you said, okay, I guess we're gonna have to do this, and y'all, yes, you do, but you all are doing better. So far, in the last 2 months, I haven't had an issue with it. So I'm counting that as a victory for us, for y'all, and for us. Notice right here, 36 pictures uploaded. I believe they may even have some more now. I need to go back there and check. Does anybody know how many pictures they can put on there now? Is it more than 36? I saw somewhere there's 45, and I don't know if it was on our MLS or on another MLS.
48.
48. Woo! Very good. Very good. Oh, one thing I'm seeing a lot of, you guys will got to watch those unbranded tours. Love those tours, but they've got to make sure they're unbranded and make sure that the virtual tour company hasn't snuck some kind of a advertising in there, because the MLS will check you. They got one yesterday on one of my agents. So just make sure, and you think, well, and it was one of the Matterports, and I don't know who did it. It was a beautiful tour. I love Matterport. But make sure that there's not some kind of advertising, because those go out through the IDX syndication, and they can't have any way of accessing or any information for them to come to you directly, because it's supposed to be general information. Measurement schedule, photo scheduled, first open house, as those are first things that you want to do when you're even that first night or first day that you're talking to the sellers, because that's part of your marketing plan, right? Because you're going to be talking about whether or not to go into coming soon or firm exclusive, right? So obviously that ties on into those two forms. And I want to remind you to do circle prospecting when you get a new listing. Those of you who are working as an individual, that's one of the best ways to begin building your sphere of influence, building your network, building that lead generation. Circle prospect around a new listing. If you've got an open house, definitely circle prospect. It makes a lot of difference when you're in the community, and works really well around an open house. And right now, prepare for multiple offers in the marketplace. And we'll talk about multiple offers another day. All right. Here's the multicolored checklist. You think I just went through a checklist, right? Basically, I did. But I just want to kind of give you a pattern of what you're going to be doing as you're taking your listings. In this checklist, this basically gives you the forms and all that you would use in a scenario. When you take your listing, and the thing that I have the hardest time with y'all on, to be honest, right here, this is a law. Did you know, have I told you that more than 10 times? This is a law that you are supposed to submit to the firm within 3 days of taking a listing agreement. Did you hear me? I didn't say it was a rule. It's not something KW requires. It is a law in the North Carolina. The listing agreement and working with real estate agents needs to be turned in within 3 days of the seller signing it. All right. So along with the listing agreement, you probably will have one of these two forms that you can turn in. It's not law that those two be turned in. However, it is MLS rule that if you do firm exclusive, that I have to sign it within 2 days and send it into MLS. So again, that's an MLS rule, and we obviously have to follow it. If coming soon is part of our listing agreement, we do not have to turn it in. However, you must determine the date that the coming soon listing is input into the MLS. So watch those dates and the timing on those dates initially, all right? Because it is very important. If you're not going to use coming soon or firm exclusive, that listing has to be input within 1 business day of taking the listing. So that's the shortest period of time you have. And if you need to extend that period of time, you're going to need to use the coming soon or the firm exclusive. All right. Now, let's come down here to the next step. All of these forms can be done after those first 3 days, but you definitely want to make sure that before you get close to the closing, that all of these things have been done. Otherwise, you're going to sit a long time to get paid, because we're not going to release your check until we have the forms that are required. All right. And I got to tell you, it's a lot easier to do the forms in this section than it is after they're closed. It's very embarrassing to go back and have to redo some of these forms, but occasionally we have to do it because it's critical to you. All right. And then this is basically the steps in closing. I'm not going to go through that right now. Let's scoot on down here with some of these forms. Come on. Whoops. Aha, there's the jewel. The working with real estate agents disclosure for sellers. When you are filling out this or going over this disclosure, keep using the word disclosure because that's all it is. It is not a contract. And there are words that you want to emphasize, and you start with this one right up here. If you have a pencil or a pen or a red marker in your hand, make sure that you circle that. This is not a contract. Signing this disclosure only means you received it. That kind of relieves their tension because they're scared anyway about all the stuff that you're pouring onto them. So just make sure this is you cause some relief on this particular form because you're going to start your discussion on agency. And notice right here, it says, check all relationship types below that may apply to this seller. In our market center, we offer seller agency, which is the listing agent. We also offer dual agency. we offer designated agency, which is a part of dual agency. And sometimes we actually do work with a buyer who wants a FSBO or an unrepresented seller. And what you want to do is help this seller that you are talking to, if they're thinking about being a for sale by owner, you're going to come from contribution and help them to understand that if they work with that FSBO, that they want to keep certain things confidential, and that buyer is going to be advised to keep things confidential. So, but these are the three things you're primarily going to explain. And look here, it says check all relationship. It doesn't say the seller has to initial. It doesn't say you have to initial. You're just going to check the one that you explain. And I would suggest that you explain these three primarily. Come down here and the seller signs it. And here's, you put your name on the bottom here and date it. And that should be, whoops, wait just a minute. That should be on in every folder. In fact, I think if I were you, I would set me up a folder. I think some of you all still use Dotloop, and some of you are using DocuSign, the opportunities. Set up an opportunity just for working with real estate agents disclosures. Not everybody that you present a disclosure for is going to be somebody that you're going to work with, but you need to have those copies in case we do get investigated. And the inspectors can come in from the North Carolina Real Estate Commission any given time that they choose to be in the area and ask to see working with real estate agents brochures. So I would suggest you might want to put some in a folder if you're not going to carry them through to another step of the transaction. Okay, and that would be for buyers and or sellers. So again, you've got to put your license number down here and put the name of the firm here. This is the brochure for many, many, many years. I can't remember when this actually started, but it seems to me like when I first started real estate back in the 90s here, we were using this brochure. And you can see it's, there's a lot of words there. So it was kind of overwhelming to people. So when we got this one-page document, we were very, very pleased. However, this brochure is still available. Obviously, you can see it is in the digital copy here if you want to send it out digitally. They've converted it to a format of questions and answers. So it is still, it's a very good brochure, but it's nice that we don't have to explain all of this as we're disclosing agency. So if you want to, and the digital copy is also in your North Carolina Library of Forms. All right, so when you go in to look for the disclosure, I believe it's Form 161. And if I'm not mistaken, they have, it's either 161A or 161B. That is the brochure. It's probably the B. Okay, if you want to send it digitally. You can also order them from North Carolina Real Estate Commission. And they're like 25 cents a piece, and they don't charge you shipping or tax. So if you want to order some, you might just want to have some of those handy. When I put together a pre-listing package, I always want to have one of those handy because it just makes the brochure look more inviting. I mean, the folder look more inviting with color brochures. Okay, I'm not going to go through that. Now, this is your exclusive right to sell listing agreement. Again, this is Form 101. If it's vacant land, it's Form 103. You will primarily use this form, I would presume. Now, let me show you one thing before we get into the listing agreement, because I'll forget it. You over here, let me open this one for you. Okay, you see this this form. It's called Offer to Purchase and Contract, and it's a sample. When you are talking to the seller, you want to give them these samples. And can you see the watermark on it? You need the sample copies because in a moment when I'm going to show you the listing agreement, there's actually a checkbox for the seller to check if they got these or not. So what I like to do is when I'm sending them the disclosures, I go ahead and send them the samples. And you can set up a template in DocuSign or Dotloop. I keep a little folder on my desktop because I don't want to have to go hunt them in those programs. So I keep me a little folder on my desktop called samples folder, samples, so that I know that I can pull that at any time and get those out to a client. So whichever way you find works best for you, but just know that you need to put the sample. Now, the reason these are used, the watermark is on there, is we cannot allow people to use the North Carolina forms that are not North Carolina realtors. All right. So when you give this out to a seller, so that the seller knows what the offer to purchase is going to look like when he gets it, then it needs to be a sample, because you don't want to leave there that night and he's got a form that's the offer to purchase without the word sample on it, that he can turn around and decide to maybe use with a buyer. Maybe he becomes a FSBO, whatever. So just make sure that if you give out a form that is part of the North Carolina Forms Library, it should have the word sample on it, unless that's another North Carolina realtor. All right. The three forms that you would have would be the offer to purchase. Then you're also going to have the professional services disclosure. Where is it? There it is. And you're going to have the questions and answers on home inspections. This one is just an answer, questions and answers form. It's not a sample of a form. And then again, the last one is your professional services disclosure and election. Okay. We'll touch base with those a little bit more, but I just wanted to make sure that I didn't forget to tell you to do those three and have them available to be sent out. Now let's talk a little bit about this, the exclusive right to list. Oh, come on. All right. When you list a property, the seller's name is going to go obviously to the top. And the second blank there is going to be the listing firm. The firm is the agent that's referred to in the listing agreements. So you don't put Keller Williams Ballantyne, Brian Boger, or whoever, LaShonda. You don't put a person's name. It is the listing firm, and it would be Keller Williams Ballantyne area. Okay. Or Keller Williams Realty, whichever. Now let's look at this right here. My goodness, I could spend an hour on all of this if I knew enough to tell you about it for an hour. But there's a lot of information in this blue box. Anytime you see a blue box, it's a note, or it's something for you to take into consideration. If it's a red box, it's a warning. So you better really read that one. Okay. But when you are doing your listing agreement, you need to find out who owns the property. We talked about that just a little while ago, right? Who you list right here has to have ownership rights to the property, that they can convey those ownership rights. As I mentioned to you on that illustration of the executor, they put the executor's name and title executor. They should, none of those people should have accepted that with written that way, but for whatever reason, it came through. But they did get that corrected. Now look right here. If the property most recently owned by a person who is now deceased, the tax listing or the last recorded deed to the property may not accurately identify the parties who should be named as seller. I've been in real estate a long time, and I have to admit something to you. I didn't know until about last year that the tax records sometimes are not accurate as to the ownership. I honestly, through the years, have thought that the tax was assessed to the owner and they might be paid by somebody else. But now, and one of the attorneys told me last year, he said, do you know that whoever's going to pay the taxes on on that property, that's the name that they're going to put in there. Now you don't see it happen very often, but the illustration I gave you earlier today, that person's name was actually on there as owner, and she has no ownership to that property. All right. Other than she's going to be an heir, or she is an heir. She's going to have some rights at that point. So all that to say, it is important not just to rely on the tax records because they can be changed and they might not actually give you the right owner's name. Again, why I suggested you might want to look at the deed to see who has the ownership rights. Okay. There is such a thing as dying with a will or dying without a will. If a person dies with a will, then they're probably going to have an executor or executrix who's going to administer the deceased person's orders in their will. If they die without a will, then the courts will have to will appoint an administrator, and the administrator then would be the one who would be responsible to carry out disposing of the property and settling the estate. Sometimes there's an attorney involved. It should be. Sometimes they're not. People just decide they'll try to handle it on their own. Not a good idea, when you come down to estates. Nevertheless, be aware that sometimes you're going to have a scenario that you need to know how to write the name up here. Is it going to be the estate of Mary Jane Smith by James Smith Executor, which that's what you'll see a lot. Or you might see Mary Jane Smith, estate of Mary Jane Smith by James PJ Kennedy, whatever, administrator, so you might not need to be a family member. It could be just anybody that they assign as an administrator. So filling out even the very first blank here can be complicated if it is an estate. All right. And you might want to speak to the closing attorney about this or who you use a lot as a closing attorney to get some advice on that. Now, this one here, this is if the property is an entity. An entity might be a corporation, it might be an LLC company, it might be a trust or some other legal entity, and we are seeing a lot of trusts right now. I didn't see it for years, but we're seeing a lot of a trust right now. So if you have a trust or if you have an LLC, that name needs to be right here. And if it's one of those family trusts, mercy, it's a long name because it'll be in the name of often a husband and a wife, so a trust will be up here and it will be signed by the trustees, which with these family living trusts is going to be the husband and the wife. If it's going to be, if there's another trust factor there, they possibly will have an administrator, but typically they're signed by a trustee. If it's an LLC, make sure that you know that it is an active LLC and make sure that you know if there's a manager, because it's the manager who signs on behalf of the LLC. And if it is an entity, you need to be responsible to get something in writing that verifies that the person signing these documents is the person who has the right to do so. You can go to the North Carolina Secretary of State website and look up the names of corporations and LLCs, and you can find out who the manager is. That would be extra work on your part if they can't give you something in writing that they have. Hopefully they would be able to provide something that would show, and in particular if it's a corporation, who's going to be the signer. Then let's come down here, and you're going to see this more often than these. You come down here if there's a divorce situation. Non-owner spouse should be named as a seller because he or she will require in most cases to sign the deed to release certain marital rights to the property. One of the most difficult situations is when we have a couple who's divorced and one's remarried, and then all three parties have to sign, or sometimes this fourth party have to sign the listing agreement in order to sell that house. So often it's the ex-wife and the husband and the new wife, and that can be awkward, but it's required unless it has been taken care of in some of the property distribution and out of their divorce. So you need to know all the people that might have some marital interest, marital right interest, because in North Carolina, we have that marital right, which is right of survivorship. And it's very important that we know all the parties that have the right to say yes or no if they're going to close on the property. Like I said, there's an awful lot in that little blue box right there. Up here, obviously, you're going to make a note that you have discussed the work with real estate agents, disclosure, and you have gotten their signature on it. And you're going to go right here to the term. Any agreement has to have a term. It has to have a beginning and it has an end date. All right. So if we're going to start the date of this, it would be the effective date would be the date this agreement has been signed by both the seller and the firm. And North Carolina Real Estate Commission says if the seller has signed it, the firm better. Okay. I had one agent try to trick the system, and he decided that he would get the seller to sign it, and he'd start all his marketing and not put it in MLS, and then he would sign it. And I said, they're not going to take that. So you got to, when the seller signs it, it's considered a listing agreement. So you want to make sure that you have your signature on it at that time. This second box here, I'm not going to go through it. I just want to point out one thing to you. Disregard that, and the reason you're going to disregard to it is this right here. Article 16 of the Realtors Code of Ethics says you shall not engage in any practice that would conflict with someone else's listing. And so if you want to read that, just know I'm saying don't do it, because you're going to get in violation of Article 16. All right, let's come on down here, the expiration date. I told you have to have a beginning date and you have to have an ending date. The ending date, obviously, is your expiration date. You can take a listing agreement for any period of time that you choose to. You can do it for 1 day. That wouldn't be smart, but you can do it for 1 week or 1 month, a year. There was a time that people was saying, I'm not going to put all that time and effort in if I don't get a year listing agreement, but not anymore. We don't need them for about a month nowadays, do we? Down here in this area, this is where you're going to get your information most of the time from tax records. You are going to ask the seller first of all, and then you're going to verify it with tax records. Sometimes the tax records are differ from what the seller might have told you here, and that's because most of the time it's the Postal Service that has assigned a different address for postal reasons, not necessarily for ownership. I'm going on to page 2. This information as well is where you're going to find on the tax records. We don't have plat references in our area. We have deed book and page. We have that. We do not have plat book or page. We do not divide out the plat reference in a legal description. Where I want you to put is right here. This is where you're going to put your legal description. Many times you're going to have a legal description that starts with an L, and then there'll be an M, and there'll be a B, there'll be some letters and some numbers, but it won't be very long, but it's longer than any other blank so that we have on here. So make sure you put the legal description from the tax records where it says other description. Don't try to sort it out. The only thing I want you to take a look at here is you do want to put the subdivision and or condominium. That name will be in the tax records, all right, the subdivision and the condominium. Put that in there. Do not put anything in these blanks beside plat. The PIN or PID, that's the identification number of the property. So this is going to be a long number that you're going to see on the tax records, and it will generally say ID, parcel ID or property ID. So you want to put that number, and when you enter it into MLS, that's going to be a hyperlink, and it's going to be a hyperlink out of MLS that goes directly into Realist. So it goes directly to that specific property. So they don't have to hunt for the property in the tax records. So you want to make sure to test it out. When you do the MLS, make sure that hyperlink actually goes to the right property, okay? So it's really important that you have that. And now the other long set of numbers would be the deed book and page. There'll be 8 or 9 numbers, and there'll be a hyphen in the middle somewhere. You might have 4, 5, 6 numbers, and then a hyphen and 3 or 4 more numbers. The first set of numbers is your book book number, and then the second set of numbers is going to be your page number. All right, so that's where you're going to find the deed reference in there. And I believe that's the way they have it in MLS. It's called deed reference rather than deed book and page. Let's come down here to fixtures. Oh my goodness, can we camp out on fixtures? Looky here. See, there's a red box here. The party should not assume that any item will or will not be included in the sale based on an oral or written statement or understanding that is not a part of a sales contract. In other words, if it's not on the pages of that sales contract, it doesn't exist. It doesn't matter if you have advertised a refrigerator in MLS that the seller's offering it. If the buyer's agent does not put the refrigerator on the offer to purchase as personal property, the seller is free to sell the refrigerator to whoever he wants to before closing. So you want to make sure that if there is some personal property that's been offered, that when you get your offer to purchase in, you want to make sure that the personal property is on there. Otherwise, it's the seller's. All right. This is fixtures are included in the purchase price. They're free of liens, obviously. There are some property, there's some property that people have that are leased, you know. Do you know some people actually lease their washer and dryer? They may just lease all the appliances, but primarily it's washer and dryer. Or they may lease like a propane gas tank. If it's leased, they don't own it. All right. So if they don't own it, then you want to come down past this list, and we'll come back to the list in just a moment. But right down here, just past on the next page, you've got 3 sections. This section right here is items leased or not owned. Let's say that could be as part of the accessory in an alarm system. It could be an appliance. It could be something to do with the fuel tanks. This is where we see a lot of things that are leased. You don't see too much of the antenna and satellite dishes anymore because they've stopped taking that satellite dishes down because it destroys the roof. And so if you buy a house that has a satellite dish, it's probably going to stay up there. All right. But in times past, they were taking those down. Now, if for whatever reason, some of the fixtures don't convey, let's say maybe one of the accessories on the alarm are not going to convey because they're leased, and they would be listed up here. But there could be one like, let's say, a Ring doorbell. A Ring doorbell is owned, all right, but it is actually affixed to the property. But sellers often think that that's a personal property, and so you might better be very clear as to the seller. If you're planning on keeping that Ring doorbell, we need to write it right here that you are not going to sell this house with that Ring doorbell. You're going to take it, but then you would replace it with a generic model of a doorbell or whatever. Sellers think it's personal property, but when it's affixed to the property like a Ring doorbell is, it's going to be you're going to need to address it right here. Anything that doesn't convey. Recently, we had a situation with one of those raised gardens. That's what they're called. You know, where some people they build up a mound of dirt with a wood around it, you know, and make a frame like a big sandbox, and they grow vegetables in it. Well, one of the sellers felt that was personal property, and the buyer felt that they were excited because they were ready to get tomatoes and cucumbers and all kinds of things in the garden. And we had quite a mess on our hands trying to figure out, was that a personal property or was it a fixture? So if you see a raised garden, make sure that you clarify file that with the seller. Now let's go back up here to this list. Look at this list. I mean, a pretty extensive list, right? But it's really important that the sellers know that what's expected to be left for the house. They're anticipating that those things belong to them, right? It doesn't, they don't think it's attached or not attached. They're just thinking, well, I bought those shelves and that I put in the garage, and I'm going to take those shelves with me. Whether they might be cabinets, but they may also be on casters, and they can be rolled out, but you might not be able to tell that. So if you see cabinets built into the garage, you make sure that you ask, are these movable? Are these ones that are fixed? Are you planning to take them? Are you going to leave them? Another thing you want to ask about is this thing right here, storage shed utility building. Mercy, when you're walking through that house or walking out in the yard, ask about that storage shed and utility building. According to this contract, they stay. All right, a storage shed, a utility building stays. She sheds don't get burned up. They have to stay with the property. So if that person anticipates carrying them or taking them with them, then you need to go down to that section I just showed you, say this does not convey, because the seller plans to take it. Another thing that you want to look at here is the fuel tank. The propane tank that's leased obviously is not going to go away, but what about the fuel in the tank? The fuel in the tank has been purchased by the seller, correct? If the seller chooses to sell that fuel back to the fuel provider, he can do so. If he's not going to leave it in the tank, then he needs to make note of it. That's not going to convey, because the seller, that's the seller's property that's in the leased tank. So sometimes we have some problems over propane gas. The buyer thinks they ought to be able to go in there and just turn the gas logs on and work. And then they find out there's no gas, and they're thinking, why is there no gas? So then they go through the exercise of calling somebody to find out who the gas provider was, and they find out the gas provider put a lock on the tank, and they can't use it until they arrange to have gas service with that provider or another provider. So just make sure, if you know there's a tank, that you discuss this with the seller. Another thing that we're very conscious of right now is the alarm and security systems. Okay, the alarm and security systems, they have so many accessories, and the accessories they're not built in. The alarms typically are built in, and they're fixed, so they stay, but the accessories are attached. So the attached where they're designed to be removed. So make sure you understand and help the seller to understand, to know what goes, what stays, what amount of money it's going to cost to buy out of their service contract. What amount of money would it cost to transfer that service contract to a buyer? Or are they going to have to pay out of it? Or are they going to have to pay it off, in other words? Or can they transfer it? Or can they take their alarm system to another house? So spend some time on this area right here. Obviously, we could go into more detail, but you're going to have to make sure that sellers understand what needs to stay with the property. Now, I just scooted past. Let me show you this right here. This was something that came in on our listing agreements last year, the unpairing of devices. Prior to closing, seller shall unpair any devices that will convey from any personal property devices. They might even have to convey them, to restore back to the manufacturing settings. I'm not sure how we're supposed to check that, quite honestly, in a walkthrough, but I hope some of y'all have figured it out by now, because that you just don't want to have any access to the house that's not granted to the new buyer. The seller should have no access, and that's what that is about. So you want to make sure that you get that taken care of. Now, personal property, we talked a moment ago about personal property. Washer and dryer and refrigerator are primarily the ones that you're going to see in offer to purchases because underwriters don't want to see anything others. Okay. If they are not going to leave those items, you want to also make sure that you put them, that you would let them let you know whether or not they're going to convey or not. You see this right here. Any personal property that will be a part of the sale should be identified in this paragraph. If they're going to sell the house with the washer and dryer and refrigerator, identified here. If they're not, nothing goes in here. All right. A home warranty. A home warranty is still very popular. Buyers really do like home warranties. Home warranties are very helpful to sellers because hot water heaters can go out when the seller owns the house, just like they can when the buyer can. There are some repairs that a warranty company will take care of when the seller has the policy in place before closing. Obviously, it'll be transferred to buyer at closing. And right now, it's not as important because that's one of the things that goes out the window, with the multiple offers. But it is still important for the sellers in a balanced market. If they will agree, you're going to put the amount of money they'll agree to. But right here, this is what I want to make sure you understand. This is a 0 or an NA. We do not take a fee for setting up a home warranty for the sellers. All right, that would be a 0 or an NA there, whichever you want to put. Now the listing price, I want you to make sure that you do a CMA. Even if you know that the seller already has in mind what they want to sell the house, and that's one of the first things you have. Well, what did you have in mind, Mr. Seller, as to a list price? Go ahead and get them involved in the discussion, and then you want to go through your CMA with them and show them the rationale as to how you arrived at a range of value that they might want to consider listing at. Now, there are times that they're not going to pay a bit of attention to you on that because they know how much they want for their house. And then you have a decision to make. Are you going to spend advertising dollars on an overpriced listing and efforts to sell it or not? Again, that's something you'll go through with some of your coaches, but just know that you are responsible to do a CMA, and that CMA must be turned into the firm because the North Carolina real estate rules say that we must have a copy of the CMA as to how you determine the price or how you advised on a price to the seller. The types of financing, make sure that you know the types of financing that house would be sold at. Make sure if the seller will accept an FHA loan, buyer, then you would need to have the approval, and you can put this in MLS. You can put a number of loan possibilities or means of selling in MLS. In your offer to purchase, you only have one, but in your listing agreement, you can have several. USDA, you need to go on the government site, usda.gov, and find out if that property qualifies for USDA financing before you advertise that it does. You will rarely see a loan assumption and seller financing. I mean, that's just totally rare. Most of the time you're going to see these as options. Now come down to the firm's compensation. The firm is requesting, in most instances, that there be a total fee of 6%. And I use the word requesting. It is not something that is established as something standard in the marketplace. We cannot advertise it that way. We cannot hold out for it in that regard. We can give options as to percentages, but at the same token, what we request and what we anticipate would be a 6% listing here. This is the total. What's that word right there? The total. All right. Now, the reason that's the total is we're going to go to the next page. Let me here. cooperation with or compensation to other firms. I already told you, we do not cooperate with subagents, so that you do not check that. Do not check this bottom one, because we're not going to be offering compensation to someone else's firm of policy. So don't even attach it. But this is the one you're going to check, because we do cooperate with buyer's agents representing buyers, and we're going to offer a certain percentage. The dollar sign here is going to be an NA, because we don't do fee for service. But right here, probably the model that most of us are familiar with through the years was 6% total and 3% to the buyer and the seller, or the listing agent, right? That is no longer what you see the most of. Right now, you're seeing probably more than anything, or 6%. If you get a 6%, you may be seeing 2.5 right here. You're also beginning it as a buyer's agent, beginning to see lesser percentages. But just know whatever amount is put in here, it has to be agreed to by the seller. All right. This is not something you fill in after the fact. It does have to be filled in with the seller. Now, back to the total fee, back up here. Let's talk about it in just a moment. Where you put 6 and you're going to put whatever 2.5 on this over here, then that would be, if it's 2.5 to the buyer's agent, then there's going to be 3.5 that's going to be on your CD that would be coming to the sellers, to the firm, to us, and then it would be passed to you. Now, right here, if a ready, willing, and able buyer is procured by the firm, a cooperating real estate firm, the seller, or anyone else during the term of this agreement at the price and on the terms set forth herein, or at any price and upon any terms acceptable to the seller, we would be deemed to have earned our commission. That's what it says in black and white. But sometimes it's not prudent for us to be able to claim what we have earned, because it's going to take an attorney to do that. Even though it states it right there, it's going to take an attorney to do it. So we have different scenarios that we work through, but just be aware that we are aware that you have earned it, and under the right circumstance, we will try to make it happen for you. Unfortunately, it's not as easy to do as we wish it were. This right here, make sure that you help the seller to be aware that if your listing expires, you're going to have a certain period of time after the expiration date, or a termination date if we terminate early, let's say of 90 days. 90 days after that expiration date, or after that date that we terminate, if that seller chooses to try to sell to someone who we have attracted to the listing, then we would still be due payment of that compensation. All right. Again, that's another one of those. I think it's a provision that you want to help people to know how to work together honestly and fairly. All right. You're being upfront with them as to what you're anticipating. And every now and then a seller, when they get rid of you, or whether it's again with termination, or whether it's the expiration of offer of an agency, then they think, well, I'm free. Why? I mean, by my listing expired, why can't I sell it to anybody I want to? Because a lot of times you are the ones that attracted that buyer. All right. So sometimes, again, we have to take a legal recourse to try to resolve this. But if indeed you do have people that you showed the house to, and you feel that they might circle back after the expiration or termination, you must turn in to within 15 days of that expiration date. You need to give a list of those people, so that that documents those people that we might have to go after him for. Okay. If, however, the seller does sign with another listing firm, all bets are off. you have no more right to claim a commission. The firm's duties, obviously, and I think this is really good that they put this right up top here. In accordance with the Realtors Code of Ethics, the firm shall, with the seller's approval, in response to inquiries from buyers of cooperating real estate firms, disclose the existence of offers on the property. If someone does have an offer on the property, you do have to disclose if they inquire of you. You do not have to broadcast it earlier, but you do have to answer if they ask you. Okay. Now, right here, these are some of the things that the duties of the firm. I'm not going to go through those because you all went through free licensing and you all remember old car and you remember the fiduciary duties, right? That just kind of explains it further. Now, we had a couple of things happen this last year that came to the forefront that have now been incorporated in our listing agreement. One of those basically is our responsibility for fair housing. We've always had that part of our contract, and I had hoped that we were abiding by fair housing. But this past year, we have had an emphasis on the fair housing, and it has been expanded to 2 categories. So you want to make sure that you see anything that's bold and capitalized. This is really important that you help sellers to understand that you are not going to be put in the position of any potential violation of fair housing. And if a seller chooses to tell you that they don't want to sell to whoever, that would violate one of these categories of the fair housing, you're going to have that serious conversation and say, I can't do that. I'm not going to violate fair housing regulations. And if that's your choice, I would suggest that you might find another realtor, and that you have to make that personal decision yourself rather than put yourself into that compromising situation. But make sure that you have that firm conviction in your own heart. Okay. Now, having said that, let's look at this little paragraph right here. You see it's in red. You see a warning. Buyer's letters to the seller. This year, the National Association of Realtors said that what we call love letters are really not love letters. They're really violations and liability. Mainly because when a buyer is trying to relate to a seller, they often will use something that conflicts with one of these protected categories. Even to the point of the name when they sign the letter can indicate about a potential violation. Or they might say a particular school that has an identity tied to it with a religious title. And there again, there's a conflict. There are so many instances that it's totally innocent, such as my children love that big backyard. I can just see them playing as they grow. You've just violated one of the protected categories. You cannot use the word children. Children is probably the most simple violation that you will stumble into is you use the word children. Isn't that sad? But that's often what would cause a problem. So the National Association of Realtors and the North Carolina Real Estate Commission have given us this warning and have suggested that we not be party to conveying a letter of such, a letter, whatever you call it, love letter, a letter from the buyer to the seller. So if we're not going to be party to it, we need to express right up front to the seller that if we should get an offer, to purchase the property. If there is a letter, I'm not going to be bringing it to you because I'm not going to be party to convey it. So you want to have that right up front. And this is where you have that discussion. Now looky here. The seller has to initial here. This is not a check mark. The seller has to initial here to say that we went over all this stuff with them so that they clearly understand, or when I can't say they clearly understood, but they can attest to the fact that you went over it with them, right? All right, let's go down to marketing. Now, this was the other big thing that changed this year. You've heard the term clear cooperation policy. Clear cooperation policy began back in May of 2020. And it has continued to be a difficult policy to implement. This is the second go around as we've tried to implement this policy. And the policy basically was to try to get people to cooperate from the very beginning. And I mentioned earlier that with the clear cooperation policy, when the seller signs it, you're supposed to put the listing in MLS within 1 business day. Well, they had to find a way to give us a little breathing room in there, because often when we sign or get the seller to sign that listing agreement and we sign it, we're not ready to put accurate details into the MLS, such as measurements. You know, not every MLS requires measurements, but ours does. So in order to have the time to do the measurements, and we always recommend professional photography these days. You know, a picture's worth 1,000 words. And I tell you, people are flipping through pictures more than they're reading the words. So it's really important that you have top-notch photography. And therefore, there's a lot of professional photographers are liking the real estate world these days because we're hiring them to do good photography. And you can't always get them on a 24-hour notice, right? So it's taking some time to get the property ready to market. And there was a time that it was considered an you were holding a listing and not it was an in-house listing, and you were holding it just so you could sell it instead of letting another agent sell it. And therefore, that's where the part of the clear cooperation policy came from, was from people who were hoarding their listings. And but now they have given us 2 ways that we can have some extra time to get that listing prepared and get that listing with accurate data out there. And one of those ways would be with your coming soon form. Now, the coming soon form is an MLS form. Okay, the concept of coming soon is going to be here in the North Carolina real estate form, but the form that actually gives you the authority to use the coming soon option is an MLS form. The other form is something called a firm exclusive, which is the MLS title. And in this document, it's called an office exclusive. And we'll talk about that in just a moment. But you want to look at this date right here. This date is the date you're actually going to start any type of marketing, whether it's coming soon or if it's public marketing. Any type of marketing you're going to start. If it's not the day that you signed this agreement, this would be, they used to call it a delayed marketing date, but that went by the wayside. Now they're just saying marketing date. It can be a delay from the date that the listing is signed. So let's say you sign the agreement on the 29th of November. But you're going to need a couple of 3 days or 4 or 5 days, and you and the seller agree that, let's say, November the 4th. You would put November the 4th, that you're going to enter it into the coming soon category, most likely, okay? So you take your listing on the 29th of November. You and the seller agree that the seller still got to paint the front door and the mailbox, and you're not going to be ready to have any marketing. It has to be a ghost listing during this time until November the 4th or December the 4th. So if you put December the 4th in here, then you can start any type of marketing. And we're going to choose which type now with our next decision. Okay. Now, our next decision comes down here as to what type of marketing. Public marketing, defined by the Clear Cooperation Policy, public marketing is when you actually have an interface with a public social media, okay? Or you're going to have a sign in the yard, or you're going to have postcards going out, you're going to do flyers out, you're going to have an open house, you're going to have all those ways that we market a property. That's called public marketing. When you put a listing in MLS, that's not public. I haven't figured that one out yet, but the explanation is that's a membership option. So when you go, you put the listing in coming soon, that coming soon option is only for members of the MLS to let them know that the listing is coming soon. All right. The kicker on that is that you can't see the property during the coming soon. Coming soon was designed early on just to get those pictures and get those that mailbox painted and get those measurements and get the house ready to go public. And it was the coming soon was designed for a short period of time, although you can in our MLS have up to 21 days. It was designed for a short period of time for the agent to get everything ready and to go on the market publicly. All right. Now, right here, you would want to, if you're going to do public marketing, which would include coming soon, you're going to have the seller's initial right here. If the seller does not want any public marketing and doesn't want it in MLS, they only want you and your firm to sell it because they want the privacy, the confidentiality, they may choose this other option. And it's called, where is it? Where'd it go? Office exclusive. There it is. Office exclusive. So under public marketing, you have two options. You're going to have your coming soon or not coming soon, which will go to MLS. And if you don't want public marketing that includes coming soon, then your seller wants the privacy of the office exclusive. And if you have the office exclusive, there is a second form called firm exclusive. And I'm going to show you that in just a moment. I was just trying to get the overall picture. All right. So you're going to begin some type of marketing on December the 4th. Remember, we signed the listing on the 29th. On December the 4th, we're going to do some type of marketing. The two options are public marketing and office exclusive. Under the public marketing is going to be the coming soon. All right. So now let's go back up here and look at the coming soon option. Right here. Under public marketing, if they don't mind letting the public know about their house instead of just the in-house with our agents, then they're going to come down here, and the seller then has the option of letting the house be marketed in the coming soon. All right, the coming soon advertising, you're going to have. Let me show you the form for that. It's down here. It's like I say, it's an MLS form, but you must have the coming soon. This is what it looks like. Coming soon, no show status. This is where it points out that any type of marketing that's done in this stage of the marketing must have the words coming soon. If you put a sign in the yard, it must have coming soon rider. If you do disclose this property to anyone, it must have, in fact, you can put it on your social media pages, but it must say coming soon. Again, the issue is it's coming soon. Here's the information, but you can't see it until it actually goes public, until it actually goes. There's an active date in MLS, and that's the date that's called the marketing date in MLS. And that's the day that anybody and everybody can make an appointment to go see the house. They then can have the opportunity to make an offer on the house, having seen the house. All right. Otherwise, you're potentially facing a violation of $1,000. And yes, they have assessed that for a few people. Someone, I'm not going to tell you that story. Anyway, it was somebody who pulled something bad to try to get into a house, and they caught them, and because it cost them $1,000. Then what you want to do is write down here on this date right here. Remember, we said the marketing was going to start on December the 4th. Well, December the 4th is not going to be this date. December the 4th is when we're going to put it in MLS. All right. What date then, once it goes into MLS, are you going to make it public? That's the date it goes active to everybody. And this would be another date. So when you put the listing in MLS and it asks for the marketing date, this is the date that they're asking for. And let's just say they're going to put it in on December 14th or whatever. So that would be the date then that needs to go into the MLS as to it's no longer going to be coming soon. It's going to be available to the public. So this date is really important that you be able to get that correct. All right. Because that's the date that people can start making appointments through showing time and be able to see the house. Yes.
Is this date different than the other date? The marketing, or they are different?
Mm-hmm. Isn't that strange?
Yeah. Okay.
Yeah, it really is.
So the other date is the day we're going live.
No, this is the day we're going live.
This is the day we're going live.
This is the day we're going live. The other date is the date that we're going to go into coming soon.
Gotcha. Okay, gotcha.
That makes sense. It's different than they did. Yeah, they just changed this 3 or 4 months ago.
Okay.
Yeah. So then this is the date it goes live, as we talk about, active to everybody. But the other date in the listing is this listing agreement is when we actually do any marketing publicly, which again is the coming soon.
So if I'm going to send out a coming soon email, this and that date in the contract needs to be like tomorrow if I signed it today. And this is the date this is going to go active where we're come schedule your appointments.
You can schedule an appointment this day. Exactly.
Okay.
Yeah.
Got it.
Good clarification.
Perfect.
Well, I tell you, it gets confusing. I have a little cheat sheet where I've written it down because whoops, what did I do? I decided to buy something, I guess, while I was trying to sell something. Now on this coming soon form, after you put in the date that it's going to go live, active, then you want to come on down here, and there's some other boxes that the seller has to initial. Oh. You know what? That doesn't look like it's the right form. Wait a minute. Oh, darlings, I have put the wrong form in here. It's very similar, but it's the wrong form. Look up here at the top date. When I was that was last year's form. So make sure when you get your MLS for your Canopy MLS form, make sure it says January. No, it's November no, it's not. It's not 9/2021. 9/1/2021. Make sure it has that. When I pull that in, I pulled in the wrong one. The same, what I explained to you is correct. What they took out is this section right here. That's when I realized stuck in the wrong one. I'm sorry. They took this out. They took that out. Now, all you have is just this one date. So you won't see that in the new form. So it serves the purpose as what I explained, but you don't have an option here. But you still need to get the sellers to sign here. And by the way, that 9/1/2021 form is in your DocuSign and in Dotloop, okay? Just make sure on that date. Now, one thing I want to show you down here, when this form is signed, whoops, wait a minute. When this form is signed, you're going to have the seller signature, property address, seller signature, the listing signature, your listing agent signature, and right underneath it, I have to sign it as the member participant. In MLS, I'm considered the member participant, just so you know my other title. So anytime you see member participant, that is for me to sign, okay? Now, I'm going to scoot back up to the listing agreement before I go into the firm exclusive. Okay. Come on. I guess I should use this, it'll be faster, wouldn't it? Paragraph 10. All right. Now, we were talking about public marketing. Public marketing includes coming soon, but they don't consider, MLS doesn't consider coming soon as public marketing because of the membership. And right here, you see this date right here? That's the date that should match that date over the coming soon form that we just looked at. So I think I said December 14th, that it was going to go live. Then right here would be December the 14th. It's going to go into coming soon, the date that's listed up here. You see right here, the commencement of market, that's when it's going to go into coming soon. And you see the marketing date right here. Then if you come down here and you look, commencing on the marketing date, if that was December the 4th, that's the marketing date, that's when it goes into coming soon. And right here, this date is going to be the December 14th date that we also entered into that coming soon agreement for the MLS. This is your state listing form, agency form. The other is the form for MLS. So you see how they parallel? So this is going to be your December the 4th. And that's the date it's going to go into coming soon. And this is going to be the date that it's going to go active in MLS and be active to public for all the public advertising. During this time, you can have signs as long as it says coming soon. If it's a coming soon, if you do not check that and you do not have that addendum, then you put out your normal signs and whatever you're going to advertise. You will not be able to use signs under an office exclusive or firm exclusive. You can't have a sign out there, right? Because it's going to be done in-house. So you can't have a sign if it's a firm exclusive, but you may have a sign if it's coming soon, as long as you say coming soon. Otherwise, you just put your sign out there. You can have open houses, not as coming soon, because that would be letting people in a house. And by the way, you are responsible for training or educating your sellers that nobody is to be allowed to come into that house. It could be a neighbor who wants to come and preview the house for their parents moving here. Sellers can't show it during the coming soon. The painter might be there. The painter cannot open the door and let somebody come in the house. You are the one who would get fined $1,000, not the painter. All right. So you got to make sure you train the seller to train anybody who is the house not to let anybody come in the house, because it could be a sizable fine for you to incur, and it's a shame. Um, we've had situations where a stager might be there and let somebody come in. I had one where we had an estate sale going on in the driveway, and the seller didn't think anything about it and let some people come in that supposedly were there for the estate sale, but they were really there to look at the house. And she said, well, I've got some stuff on the inside. She invites them to come on in, and they wanted to write an offer. Well, then that caused a conflict because she had showed the house during coming soon, and they had immediately had to go into the MLS as active. And fortunately, nobody turned them in. They didn't get the violation, but they could conceivably have been fined $1,000. So anyway, just be cautious of that. Advertising on the internet, everybody wants to be on the internet, except those people who want the privacy. And if they don't want to be on the internet, they want privacy, they want just the agents in our market center to be able to sell their property, because again, it's keeping it private, then they're going to use they're going to use this option. They're not going to do anything with those first things I showed you. They're going to use this option. And in the listing agreement, it's called office agreement. In MLS, it's called firm exclusive. Now let me scoot on down here and show you this form. Okay. Where'd it go? There it is. It's called firm exclusive. And this is the correct date on it. Nothing really changed on it. The firm exclusive, as long as the sellers understand that it's not going to be advertised in the manner that we normally are going to advertise. It's not going to be on this, it's not going to go out to the syndicated sites on IDX. It's primarily going to be, it can be advertised as, like, if I'm an agent and I see a firm exclusive in our what is it, our internet website, we can then we can contact our sphere and we can try to, get a buyer that way. Or maybe we already have a buyer who wants something, a property like that. Then we would then make an appointment with the listing agent. You can't make appointments through showing time. We would make an appointment with the listing agent in order to be able to show that property. And we would not have any information basically from that would have been in MLS, obviously, because it's withheld from the MLS, and and it's sold, and the information is conveyed only within the market center. So you have to go through all that explanation with someone who wants that privacy. Sometimes public figures. We sold a house not too long ago. Well, it's been 2 or 3 years ago now, to a very popular recording artist, and he did not want anybody to know where he was buying. He was trying to protect himself from that standpoint, that he's a very public figure anyway, but he wanted his home to be a private matter, and so the firm exclusive worked really, really well for him. Now let me show you. I showed you the pattern of signatures a while ago. This looks very similar. Oh, fiddle! Come on. On the bottom of the page, you're going to put the address and the name of the brokerage, obviously, with Keller Williams Valentine. Now they're put everything in red boxes for the sellers to be aware of and the sellers to have to sign. And they come on down here to the bottom, and there's that same pattern that's on the coming soon. You see, whoops, where'd it go? It looks very similar anyway. You're going to have the signature of the sellers. And this asks for the name of the listing agent. I guess they weren't sure if you're going to be signing it where they can read it. And then you get the signature of the listing agent. And there's that signature again for the member participant. See that? That member participant is what I have to sign. Now, let me tell you the significance of this one. This form has to be signed within 2 business days of you signing the listing agreement. I have to submit it to MLS as letting them know that we actually do have a valid listing agreement on this property, but it is a firm exclusive. So that if they get a complaint or get a call that that they know some of the houses for sale and they didn't have any information, they do have it in their database that it is a firm exclusive. Now, if you are going to send this out to someone, to the sellers for signatures, you know, in DocuSign, you can do that order of signatures. I love that feature. Have the seller sign it first, then you sign it, and let me sign it last. Don't send it out to all of us at one time, to whoever signs it. Send it out, you know, put your order in there. So when it comes to me to sign it, I can immediately get it into MLS, all right? And make sure that you set it that I be able to get it within the 2 days. Now up here, this right here, where it says seller does or does not authorize the listing brokerage to enter the listing into the MLS system as a comparable sale once the listing is closed, make sure that they check one or the other of these boxes. It's rare that they don't, that they say do not put it in, but MLS will kick it back to me if I don't have one of these checked. So make sure we have these checked, make sure you get the signatures here, and make sure that I sign it and send it to me so I can sign it and send it to them within 2 days. Okay, now let's go back up to the listing agreement. Oops, I went too far. All right, 10, that's what I'm looking for. All right, so I hope you've got a better understanding or a little bit more a clearer understanding of the marketing. Again, it's changed. It's changed about 3 times since May of last year, and it does get confusing because of the changes, but they're trying to simplify it because it had gotten pretty cumbersome. But I hope that knowing those dates will make it a little easier for you. One thing I did want to point out to you, if you use that office exclusive, that firm exclusive form, make sure that you know that it can be terminated. Where is it? Well, I keep popping past it. I'm sorry. I know it's in here. I don't know why it's not coming up. I keep going past it, I guess. That is. You see this little note right in here? If you start with a firm exclusive and the seller finally says, you know what, I'm not getting the action that I want on the house, I would really like to terminate the firm exclusive and go into public marketing. You can do that. And the way you do it is use Form 710. See where it's listed right here? And you would terminate that firm exclusive. And then you could also, in that same form, list if you're going to go coming soon at that time, or if you're going to go straight into public marketing. I have a template I'll be glad to make available to you. It's in our the KWB resources under general office forms. It's in there where it kind of tells you, or it's a template of terminating the firm exclusive and then going into the coming soon stage. And then you would have a firm exclusive form first, but then you would have a coming soon form because you're going to terminate the firm exclusive, but you want to have it in coming soon for a few days. Most of the time when they go out of firm exclusive, they go directly, active, but you still can use the coming soon if you want to. And if y'all can't find that form, let me know and I'll send you one over. Okay. Right here is where the seller's going to authorize lock boxes or not. And I've already expressed my opinion on lock boxes, and I hope you'll convey that to the seller. Now, the other thing on this one, you want to make sure that you explain to the seller, we do not hold earnest money anymore. Our trust account is not an active one. So you want to make sure that you check off here that we do not have a trust account anymore. Seller representations, a lot of these boxes going up forward, these are boxes that you're going to need the information to fill in the MLS listing on them when you put it in the canopy. All right. This is one of the fields. Has the property been owned by this particular seller more than 1 year? at least 1 year or less than 1 year, or does not yet own the property. Every now and then you'll have one of those situations. They don't even own the property. And I told you a while ago to make sure you know who the owner was. Well, you still need to know who the owner is. This generally applies to like a relocation seller. Every now and then you'll work with a relocation, a seller who is moving and has relocation benefits. And if they do have relocation benefits and you're helping them sell their house, what will happen is before the sale is consummated or closed, the relocation company will buy the house from the employee, the transferee, the seller, and they then will become the seller. And it generally happens like just a few days or sometimes 2 days before closing. So in that situation, the seller would not yet own the property. That because then they have to do a listing agreement too. And I know that's more complicated, you need to know right now, but just to know there are scenarios, only a few, that would not yet own the property. Now, this part right here about bankruptcy, this is probably the most sensitive questions we ask them. And I'm very careful and cautious when I talk to them about the bankruptcy and asking them, and I tell them why I'm asking them before I ask. Okay, when we need to know if there is a bankruptcy initiated or in place, we can't sell the property if it's protected by the bankruptcy court. And every now and then we have to get the seller to have the house pulled out of that protection if they want to sell the house. All right. There's no sense in us putting it on the market if we can't sell it. So you have to have a little bit of an explanation with them. And if they are contemplating bankruptcy, or if they were in bankruptcy, they need to talk to the bankruptcy attorney and determine if they can sell the house outside of the bankruptcy protection. And that's why we have this section in here. And the only reason we need to ask is whether or not it would prevent us from even listing the property. Okay. You need to find out about private road access. All properties that we list should have public access. All right. If it's a private road, there should be a private road maintenance agreement. I live out near Matthews Mid-Hill area, and we have a lot of neighborhoods that maybe have 3 or 4 or 5 houses on them, and it might be a little gravel road, down to those houses. It's a family probably started it years ago, and they just kept adding houses back there. And the families just they fix it when they need to fix it. But if an outsider is going to be purchasing a house down that little gravel road, that person needs to know who's going to fix the road if it needs maintenance, because then they should have a road maintenance agreement. And it's not always the easiest to get, but you do have to have one. So make sure that if that the seller knows if there is one or is not one, and that means you might better get one prepared because it's going to be needed. If there is a manufactured home, a mobile home on the property, that cannot be sold unless it has been detitled, or unless it's a personal property that's just left on there. So you would definitely want to put the VIN numbers there. The homeowners association, it's very important that you put the homeowners information here, and make sure that you know if there is a second homeowners. There are a lot of neighborhoods now that have not only have the initial one that would be for like a condominium, let's say, or for one section of the neighborhood, but you might have what's called a master HOA that would be responsible for the entire development. So just make sure you know if there's more than one HOA, and make sure you listen. Remember a while ago I showed you the sample forms? Right here is where they need to check if they received those forms, and that's one of the things those investigators look for to see if you actually gave it to them. This is where you have a termite bond. If they have a termite bond on the house, you're gonna ask for that. And fill in what the amount of money it will take to transfer that bond, because most of the time when you have a bond on the house, you want to keep it, all right? So make sure you know what the cost is and who it's with. And again, this is where you're going to put the information about the loans. If they will provide that to you, and hopefully they will. Most sellers do. Sometimes they don't want to take the time to go get on the computer and find out, but you can get that from them and off the computer. If there is a lease on the property already, then you want to make sure that you fill out this part and make sure the seller understands that the lease must be provided to prospective buyers. And if it's with a property manager, obviously we'll put the information here. This is a check mark about the FHA appraisals. And you've probably already heard, if FHA appraisals stick with the house. If this seller had this house listed with somebody else and they had a fall through on a contract and they had an appraisal, that FHA appraisal is going to stick with it for 4 months. See right here. So whatever, if you attract another FHA buyer, then the price of that, the price of the property cannot exceed whatever the price that appraisal value was. So just be conscious of this and make sure that the seller understands it. Okay. Special assessments. This has become a real big issue, an assessment. So you need to find out from the seller and from the homeowners association what assessments are in place on that property. And this back up here is a fuel. We talked about this earlier, so I'm not going to go into that. The other thing I wanted to point out, of course, like you said, we could spend a lot of time on some other details, but we're not going to right now. I just want to point out to you that in this agency agreement, the listing agent's agreement, this is where you're going to explain in detail what dual agency is. In the work of the real estate agents, you're just going to give a snippet. But when you get into your agency agreement, this is where you explain in detail what is involved in dual agency and designated agency. And do not miss this right here. To this pattern right here. Excuse me. The seller authorizes the firm to act as a dual agent representing both the seller and the buyer, subject to the terms and conditions set forth in paragraph 17. That's what I just explained. That's the detail. Now, you see where it says seller authorizes the firm to act as a dual agent? They didn't say seller authorizes agent, which you would assume would be the individual agent to be a dual agent. It says the firm. If they will authorize the firm to be a dual agent, then they can come down here and initial right here that they want you as the individual agent to only represent them. That way, if someone from Ballantine, another Ballantine agent comes in as a buyer's agent, they're going to automatically be designated to take care of the buyer. And you are designated to take care of the seller, right? If the seller doesn't mind if you are the individual dual agent as well, they would not necessarily sign this. Because this is for the firm and it can apply to you because you're the served agent of the firm, all right? So you want them to, in almost all instances, you would prefer, but it's still their choice, you would prefer that they give the firm the right to be a dual agent, because we have 500 some agents out there and we do not want to shut off that opportunity for another one of our Ballantine agents to come in and sell your listing. And that's where they would be designated as buyer's agent and you would be designated listing agent. Now, if they just totally don't want to do another thing with another agent in Ballantine, the firm, then they're going to initial right here. But rarely do I see this. And when I do, it's most often because the agent wasn't clear in explaining why it's to the seller's benefit to allow the firm dual agent and then opt for the designated. So don't miss this little section right here, because that's probably the most critical part of the agreement. And then you're basically pretty much through your listing agreement, and you start right up front talking about wire fraud. I just talked to an attorney last night about another matter. Brandon, Brandon and Brian gave me an exercise yesterday. So, but he's doing a case right now where an agent disregarded all the things that are in here. The agent is the one who's probably going to lose his license and maybe several $100,000 because he did not abide by what we tell even the buyers and the sellers. You've got to do everything verbally when it comes to wiring. It has to be verbal, and it has to be verbal with somebody you know and you trust. You recognize their name and their number, because there's so much hacking going on and so many billions of dollars leaving our country every year, according to the FBI. So don't miss this warning and start right with the listing agreement or the buyer's agent's agreement. And of course, it's in your offer to purchase as well. And well, I have talked right through our 2 hours. I would love to, maybe next time I'll start here and we'll continue on with some of these other forms that we need. What do you think? You want to try that? After you get everybody, the sellers signed, make sure if they're not in the house, make sure you have a mailing address, but more importantly, make sure I have a cell number, an email. And I mean, when it's turned into the firm every now and then, we have to have that. And I can't always track you down to get it. All right. So I want that in there. If it is an LLC or if it's an entity of some type, a trusted, make sure that they sign here and as an entity seller. And this would be your LLC name or the trust name. And this would be a signature by the person who has the authority to sign for it. And they are given that authority generally because of the title that they have. All right. So you're going, and then this is where you would print their name, where this would be your signature. And again, down here, we're going to go into the Keller Williams Ballantine, and this is where your individual signature goes and your individual number. The firm license number is capital C 13291. That's where we go here. C 13291. Well, thank you for letting me finish this one form with you, and I appreciate the extra time. And we will meet next week, and we'll talk about North Carolina buyers, and hopefully talk to you all a little about how to work with the buyers as the listing agent. Would that be good, helpful to you? Well, I've enjoyed being with you. All right. You know my number and you know my email. So I look forward to hearing from you. Y'all have a good evening. God bless you. Bye.
Thank you, Sabra. Bye.
You're
Thanks,
welcome.
Sabra.
Bye. Bye, y'all.